Today's topic, I think more or less everybody is familiar with. Whether you're a lawyer, you're not a lawyer, it does not really matter. Because जो ये word defamation है या मानहानि है, ये इससे सब वाकिफ है. Everybody knows this. So today what I'm trying to do is, I'll try to break down this law concerning defamation. Now defamation as a term, you all are very familiar. Now what is defamation under the law, the consequences of it, and the exceptions or the loopholes as to when something can be considered defamation or not is a matter of legal jurisprudence. What you or me as an individual, when we talk to each other, what we may find defamatory, may not be something that could be legally defamatory. So this distinction that separates our understanding of the term defamation compared to what actual defamation is under the eyes of law, that is what we'll be focusing. So any law in our country or anywhere in the globe, the basic distinction or the basic demarcation is a law is considered to be civil, a law is considered to be criminal. Under that, it branches out into several finer aspects of it. But the broader distinction between any law is either the case is civil in nature or the law is civil in nature or it is criminal in. Now, when we come to this term defamation, it is both civil and it is criminal. So that is the first introduction with regard to the word defamation, that defamation can be a civil wrong, defamation can be a criminal wrong. Now let's elaborate on this. First of all, as far as the civil law of defamation is, there is no definition given under Indian law on the civil side of defamation as to what are. There are several case laws and there is a basic understanding that comes from the English common law, which we very commonly call as law of torts. Tort is the French equivalent of the word wrong. So tort means a wrong. And we have heard the Latin phrase "ubique sibi remedium," the ones who are familiar with law. Wherever there's a wrong, there is a right. So we as a country have adopted the laws, the English common law, that is the Britishers. So most of our laws comes from that. So the first thing that came to our country was a common law of English, which we call the law of torts. In short, if there is no codified legislature by the state legislature or the parliament of our country, we stick to the civil remedy for compensation or damages that a person can claim when he believes a case is made out where some damages has been suffered by him. So that is what law of torts. So defamation is a tort under the civil law. So now, for a broader understanding, like I said, defamation is not defined under the civil law. So from a law of tort perspective, if you were to analyze the word defamation, what amounts to defamation? No definition. So let's just understand what is deemed as defamatory. So one very important thing for what is deemed as defamatory is anything that subjects somebody to hatred, contempt, ridicule, or strong public condemnation amounts to his or her defamation. Similarly, if any loss or injury is caused to his trade or profession, his or her trades or profession, then causes that person to be shunned or avoided by the society at large because of something that is said about him or written about him, that amounts to defamation. So I think this is something that you all will agree to. This is basically a layman's definition, even though I've put it with some words which have some legal meaning or legal terminology to it. Simply put, whatever causes you harm to your reputation or character in the society because of something that was said against you or written against you that reached out to those public, because of which they judged you and it caused you harm. So the basic definition of defamation is that. Now, if you see, back then when I was a law student, a professor of mine told me that before you study law, you need to keep it very clear in your head that law is ultimately codified common sense. In my previous lectures also, when I was addressing other aspects of CRPC and the other laws, whichever I've covered so far on PLEA, I've come to this particular line, that law is codified common sense. So I told that a layman is very much familiar with the term defamation or मानहानि. तो मानहानि जो है, हर individual को पता है कि मानहानि क्या होता है. अभी हम इसके legal aspect पे बात. But because we are aware about the term, any lawmaker or the legislature or the parliament, anybody who has come to this particular aspect of law has thought it from a codified common sense point of view. And this codified common sense comes from where? The codified common sense of the public at large for which the law is built. So in the Indian society, what causes you to be shunned, causes hatred to you, contempt to you, ridicule to you, is the basis on which the defamation laws are made, both civil and criminal. So now on the civil aspect of the side, I already have come to the aspect where it is that the civil law is such. So when the civil law is the aspect I told you, no definition, but these are the aspects that is covered, what amounts to defamation. Now, when I compared it with the law of torts and specific statutes, the criminal law addresses it in the point of a properly defined section. Civil law does not. I've already covered that. So what comes under the law of tort is not covered by a statute. So basically, three principles are applied in the law of torts. So if something amounts to definition and definition is not defined under the law of torts, then how do you conclude that? How do you come to if a case under civil law of defamation comes before a civil court of law? How is the judge or the court supposed to adjudicate that matter? The judge or the court is supposed to adjudicate that matter based on three basic principles. The entire law of tort is based on the three principles, that is justice, equity, and good conscience. So the common law system, which we call it law of torts, actually says that any litigation that arises under the common law, under the law of torts, has to be adjudicated based on these three principles. That is justice, equity, and good conscience. Whereas if you see, we have consumer law, labor law, family law, contract law, company law, arbitration law. Now these are specific civil enactments. So our parliament has made these civil laws explaining everything in detail, defining terms in that, defining the punishment, defining the amount of compensation. Everything is elaborately mentioned under a specific statute made by the parliament. But like I said, such specific laws don't apply to the law of defamation on the civil side. So if I say that मेरा मानहानि हुआ है और मैं civil court में जाता हूँ compensation के लिए against the person whoever passed that defamatory statement against me. If I approach the court of law will decide the case of compensation or damages that I'm entitled to based on the three principles: justice, equity, and good conscience. There is no other driving law that mandates a civil law to consider something as a part of a restriction or as a part of, that acts as a guideline for it to decide or arrive at the amount of compensation. And under the civil law, like you all would be aware, there is no question of imprisonment. So nobody goes to jail if the case is about civil defamation. So the whole summary, what we can derive from civil defamation is this, that the law is not defined under civil law, that the adjudication of a civil defamatory case is based on justice, equity, and good conscience. No other deriving law, no other force of law behind the court to reach a stage of adjudication. So civil law basically covers this aspect of defamation. Now coming to the aspect of criminal defamation. Now criminal defamation, now we have a new law under the Bharatiya Nyaya Samhita. But the problem is, in the new law, there is absolutely no change. Only thing is that it has been comprised and compacted into one particular section. In the old law, 499 used to define, that is the Indian Penal. 499 used to define defamation. And 500 was the punishment for defamation. Then 501 and 502 focused on printing of matter known to be defamatory and sale of printed or engraved substance containing defamatory matter. Basically, a different section compartmentalizing what is printed, what is not. There was this particular section. Now, though those provisions are still there, it is all put into one particular section. So now the section under the BNS for any current offense after July 1 will come under 356 subsection 1, 2, 3, and 4. So now we have four subsections. First one, it was four sections: 499, 500, 501, and 50. So now we have it under 356.1, 356.2, 356.3, and 356.4. But the provisions are verbatim. There is absolutely no change in the contents of these sections. Under the DNS also, under the old IPC also. So now the whole idea is, under civil law, now defamation is either a libel or slander. So libel is written, slander is spoken. So this is the base in both civil and criminal. But the whole aspect is the criminal law goes a step further and puts it into a form of a definition. So now let's understand the definition under the criminal law. I will read out the section and I will just come to the entire crux of it a little late. So if there are law students and advocates would prefer referring to something, I'm just referring to the bare act so that you all know. So 356, like I told you, it's the old section of 499. Whoever by words either spoken or intended to be read, or by signs or by visible representation, makes or publishes in any manner any imputation concerning any person intending to harm or knowing or having reason to believe that such imputation will harm the reputation of such person is said, except in the cases wherein after accepted, to defame that particular person. So what is the crux of this particular definition? If we were to simplify and put it in a few words, there has to be some words or signs or visible representations with the intention to harm or with the knowledge or belief that such information will cause harm to a person. So that is the breakdown of this particular definition. Now the definition is only one. Now this particular section elaborates onto the aspect of explanation and exception. where this definition is not applicable and what are the exempted. So that is what the criminal law on defamation covers. So now I will come down to the exceptions. Exceptions are very important because, and I will give good hypothetical examples also. Some illustrations are already covered under the penal, and some I will give you from what I have learned from my own experience also, and from case laws also. So I'll come to that a little. So now if you see, well, first of all, the first exception. I'm not focusing on the explanation aspect. I'm not reading it out because I think you all can refer that later. Because if I do it, it just becomes too bookish and I just don't want to refer to that. I want to make it very simple for you all so that you all have an idea, and when you read the law, it is going to make it much easier for you to understand. So that is my intention. So therefore, I'm not going to go for every word and every line that is written here. Though it is here, you all can refer it to it. But I'm going to make it very easier and I'm going to explain it very simply. So I'm just going to not read those explanations that are 1, 2, 3, 4 because it's just like a further clarity. I would rather readily jump onto the exception because the definition coupled with the exceptions will make it very clear for you what is the law of defamation on the criminal side of it. And then we'll have a comparison and we'll open for Q&A. So the first exception is truth for public good. Now, in this particular aspect, what you'll need to understand, anything said about anything with a good intention for the public good is considered as an exemption in the law of defamation. Now, if you see, that is the first exception, and there is no illustration provided in this particular aspect as to what is truth for public good. Now, I will just say that I will give you a good illustration of my own thing. Imagine a hypothetical scenario where A and B are friends, and A knows that B is in the habit of watching pornographic content on the internet frequently. Now, A goes and tells or posts on social media that my friend B is a habitual person who's addicted to porn or always watches pornographic movies. Now, in this particular statement, if A has done this to B, though there is truth in it, can it be considered non-defamatory? Because what A has stated about B is the truth. But did any public good come out of it? Absolutely no. Because if A tells the world that B watches porn, the world does not benefit from this particular knowledge. So A's pure intention was to defame B in the eyes of the society because he will be traumatized, stigmatized. He'll be judged by the judge. So unnecessary harm is caused to B's reputation because of the thing that A said about B. So in this particular aspect, if you see, what A has done is defamatory because though there was truth in it, it did not amount to any public good. Now let's actually tweak this hypothetical a little so that you'll understand when this truth suddenly becomes good for the society. Let's just say A knows that B watches pornographic content, but he watches pedophile pornographic content. Now, you know that under the law, watching porn amounting to that of a minor is an offense under the Indian law, under the various provisions of the IT Act and the penal provisions. So now, if A, in the interest of the public, goes and tells people that I'm afraid of B's behavior because I've been consistently seeing he's somebody who watches pornographic content concerning minors. So this is not considered to be good. So you are informing the public about a truth that you're aware, and you are informing this why? Because you want to inform it either to the law enforcement authorities or you want to inform it to the public at large that be aware of this particular man because his intentions are not good. So now, when you tell a truth for the benefit of the public, you're actually doing it so that to bring awareness or to warn the others of a possible offense that could take place in the future or an offense that is already taken. So in the same example, you understood how a truth, even if it is a truth, does not matter unless it serves the public good. And a truth, even if it is defamatory, even though B was heavily defamed because of the thing that A posted, still it is not counted as defamation because A's intention was to inform the public of a wrong that was happening, even though that caused the reputation of that particular person. So here in this particular scenario, telling the truth for public good is the first exception. Okay. Then we'll come to public conduct of a public servant. I think I don't need to elaborate much on that. The exception number 2, it says that in good faith, if I criticize the action of a bureaucrat or a minister or a judge or anybody for that matter, who I know is a public servant, is on the tax, who actually draws a salary based on what the taxpayers are paying, serves the society. So any public servant comes under public scrutiny. So if I criticize a public action office, it has nothing to be in his personal capacity. Like if there is a municipal commissioner who is not doing his job well as a municipal commissioner, I have concrete material. I point it out to that community. I take it to social media and I criticize this particular commissioner. I have done nothing wrong as long as I focus on the aspect of his public governance aspect. If tomorrow I post something that in family, this particular municipal commissioner is a very silly husband, or he's a very silly father. That has nothing to do with his public service. That would amount to personal defamation. Because I'm not focused on his public chores, I'm rather focusing on his family, which is a bit beyond my jurisdiction. So you can attack a public servant with material, with cogent material, in good faith. Because after all, he or she is supposed to serve you, draws money or draws salary from the taxes that you are paying. So therefore, any statement made or any public conduct of a or made or public conduct of a public servant is scrutinized by us. And if we make a statement regarding that, even if it causes defamation or even if it causes scrutiny or hatred or contempt by the public at large to that concerned officer, it does not matter as long as you did it in good faith. That is second. Then third is conduct of a person in relation to any public question. Now, we covered the aspect of public servants who draw salary from the taxpayers' money. So of course it's more like a हक बनता है. हम जनता है, हमारी taxes से इनको salary मिलते हैं, तो हम इनको criticize कर सकते हैं because हमारा हक. That is because they are public servants. But it does not just stop there. Now we as fellow citizens, let's just say another citizen comments something about an action of the government or any public policy or for any public law for that. Let's just say hypothetically, person A makes a very harsh comment against the government of India that the actions by the government of India in Jammu and Kashmir were not good. A very big statement. Now, person B, let's just say it's me or anybody else, did not like the statement that A made against the government. And I take to Twitter or I take to any social media and I tell it to them that Mr. A's view is very shunned and he is trying to incite violence. Okay, or he's trying to create animosity between people. I'm entitled to say that because what Mr. A commented was concerning my country, against my government, and against some policy enacted by them. So A may not be a public servant, but A's conduct or A's comments were concerning a public policy or concerning a public matter for which we all as citizens have a right. So we can comment about A or the manner in which A conducted himself with regard to that particular state. Now, I cannot come and say that A is always in the habit of criticizing the government of India because he may be brought by the opposition. That is not mine. Because the whole aspect is, for that particular aspect, I have no material. If from the actions of A, those actions are criticized because it concerns public, I'm very well in my right to do that. But I cannot go a step further and insult him or throw some imputation against him for which I have no material against, or which his actions will not display. So that is conduct of a person in relation to any public question. Now, fourth is publication of substantially true report of court proceedings. Of course, we have an open court system, except for cases which are conducted in camera, where it is behind the closed doors, where sensitive matters like rape or POXO related matters or something like that, where the identities of the parties involved are protected. Except in those cases, whenever a proceeding takes place in open court of law, where anybody is free to visit the court or actually see the hearing, such proceedings are considered to be open. If something happens in open and a substantially true report of what took place in the court during that particular hearing, there is no harm in reporting that. So if there is a case of defamation only going on in a court number A, and there are two counsels arguing based on the two parties involved in the case, counsel A says ABC, counsel B says XYZ. Now, in quoting that ABC and XYZ as an argument from both sides, quoting it perfectly, like a substantially true version of what was argued by those respective counsels in the court of law, or what was remarked by the judge in that particular day of business, everything can be reported as long as there is no distortion of it. So it has to be a substantially true report of the court proceeding that took place on that particular incident, or that took place over a series of time. So as long as it is substantially true, there is absolutely no bar for reporting court proceeding. Even if, let's just say, during the court proceeding, something was said against a person, and that person could just say, oh, I was defamed because of that thing that was reported in media regarding the case proceeding that happened today. No, he cannot say that. Because though he may be a party to the proceeding, because it happened in open court, everybody has a right to hear what is happening. So if somebody reports that, it does not amount to defamation. Then, merits of case decided on conduct of a witness or other party. Now, with regard to this is an exception 5. Illustrations are already provided in the, if you see under the penal law, DNS gives 2, 1, 2, and yeah, there are 2 illustrations. And I think those illustrations are really good. So I'm going to read them out, I think, because that will give you a good understanding of that. So any case that has been already discussed, you can of course have your views about it. When the Supreme Court decided the Sabrimala issue, whether menstruating women should be allowed to visit Sabrimala or not, after the judgment came out, there was a huge fallout. A lot of people did not accept that judgment. A lot of people did not find that judgment to be sound. A lot of people supported that particular judgment. So it is within the right of the people to criticize that judgment, even to tell that the Supreme Court is wrong in passing such a judgment, unless you resort to some kind of violence. You're well within your rights to criticize the Supreme Court that we don't find this judgment to be right. It's okay. You're entitled to your opinion. So anything that is decided by a court of law can come for public as long as it is done in a rightful. You are always entitled to express your opinion about any public decision that has been taken by any public, whether that is court or something. So therefore, it is very clearly stated in exception 5 that merits of a case decided or conduct of a witness of the other parties. Now, regarding the conduct of the witness, see, the two illustrations are about that. A says, I think Z's evidence on the trial is so contradictory that he must be stupid or dishonest. A is within this exception. Though he called the witness stupid and dishonest, still he is covered under this exception. You know why? Because A is within the exception if he states it is in good faith, in as much as the opinion which he expresses respects Z's character as it appears in Z's conduct as the witness and no further. For example, this illustration goes on to say, I'll put it very simply for all of your understanding. If let's just say there's a witness on the witness box and he says something that I was at 8 p.m. at a restaurant number 8. If in the next couple of minutes later during the cross-examination, the same witness says, at 8 p.m. I was at the gym. Now, this is a very contradictory statement. You said that at 8 p.m. you were at a restaurant. Then, after a couple of minutes, you don't recollect that and you say that at 8 p.m. on this particular date, I was at the gym. So now everybody has seen that in open court that this particular person has contradicted that particular person through his own statement, his or her own statement. Now, if there is such a contradiction, me calling the witness stupid and dishonest for this particular aspect will not amount to defamation. Because why? It actually happened. It is a true report. And it seems very futile. It seems very stupid. But this goes on. The second illustration explains this only situation further. If A would have said that I do not believe what Z asserted at the trial because I know him to be a man without veracity, then he is not covered on the exception. Basically, you are forming a character opinion about the particular witness and you're drawing that character opinion, which does not sound right, without any material, based on your own knowledge, and you're judging that particular witness for saying something during the trial. Now, that is not an exception. Because when you say that he's a man without veracity, and that is the reason why he's saying ABCD stuff in court, that actually harms his reputation without any material. So therefore, true reporting, like a true criticism or a good criticism about a case that is decided by a court, or judging a particular witness for the mistakes he or she made during the course of the trial, is permitted as an exception, but not beyond that. So that is exception number 5. Then we have exception number 6, merits of public performance. Now tomorrow, for example, if suppose now we saw the hue and cry during the Coldplay event. So if let's just say tomorrow I just say that Coldplay should not have performed that particular event because it caused chaos in the stadium where it was hosted. Coldplay cannot sue me for defamation because he has subjected or they have subjected themselves to that particular concept to the public. And whatever happens there as a part of that consequences, they will come under that criticism. So as long as I stick to my boundaries where I judge their artistic effects, or if I say that I do not like it, that the hype is not worth it. Their performance at the show is not that great that tickets have to be sold for 3.5 lakh rupees. So now tomorrow Coldplay cannot sue me and say I judged their performance and I did not like the performance, or I said it is not worth it. That is my personal opinion. I don't like your songs, or I like your songs. So in this kind of criticism against any singer, artisan, musician, whoever it could be, if you submit yourself to the public opinion through any artistic expression, be it a dance, music, picture, drawing, anything, you have placed yourself in the hands of the public to criticize that particular way. It could be an appreciation also, it could be a criticism also. You may like it also, you may not like it. But you cannot sue anybody for defamation if you have subjected yourself to public performance. So the 6th exception is merits of public performance. Then 7th exception is censuring in good faith who has lawful authority over other. Now, we advocates, I think the advocates will relate this to me a lot. When we go to the court, we file a case, we argue. Sometimes we do make mistakes. Sometimes we may not do it properly and a judge may scold us in open court in front of everybody. Now, can I sue the judge for defaming me in front of my fellow colleagues or my clients or the other observers in court? I cannot, because the judge is censuring me because he's the presiding officer of the court. I am an officer of the court. So I am there and he is censuring me or scolding me, or he has made some point against me because it comes in his jurisdiction and he is doing that in a supervisory capacity. So you cannot say that a person has defamed you if he is censuring you if he or she is censuring you under good faith because of the virtue of the position that person, and because that person has lawful authority over that particular person. So if they criticize, or if they say, even in front of others, they make a harsh statement against you that you have not done this pleadings properly, that your prayers are not in order, that your judgments are very bad, your research is not good. Even though this may not sound very good for you in front of the court, the judge is not wrong. So this is just an example I'm giving. So that, just to show, I think this even, and the illustration covers that. Yeah, I think section 6, 7. Yeah, even a judge censuring in good faith the conduct of a witness. Sometimes a witness on the stand may actually go out of bounds and talk more than he or she is supposed to. So judge may say, please don't talk. Just answer what you're asked. Just answer the question to which you're asked. So just because the judge scolded the witness does not mean he has committed defamation against that person, because he's censuring the particular. And I think that a parent scolding the child, again, it is because the parent is a lawful guardian of the child. So if the child makes a mistake, the parent or a teacher could scold the child in front of 10 other people. So the child cannot say that my defamation was caused because it's a scolding by the teacher or by that. So that is the exception on the 7th. Now, 8th one, accusation in good faith to authorize. Now, if suppose, let's just say I'm a witness in a trial and I have been called as a witness, and there is somebody who's an accused against whom I have to make a statement. Let's just say I saw him stealing. Now, I come as a witness and I tell the judge in that particular court that I saw Mr. A stealing so and so stuff from so and so place, and he's a thief. Now, Mr. A cannot sue me later by saying that I defamed him because I called him a thief, because I'm actually reporting a crime to a lawful authority where I was called under lawful jurisdiction. So I was a witness in the case. I told this to a judge, and therefore, because the submission was made against that particular person in a proceeding before a lawful authority, that accusation that I made against that particular person will never amount to defamation. So that is, I think it is very easy to explain. So that is the exception under 8. Now, exception number 9, imputation made in good faith by person for protecting his or another's interest. Now, this is a very interesting thing. Now, let's just say I purchased A from a particular shop. A thing from a shop. Now that A thing did not turn out to be of good quality. So I go and tell 2 of my friends that please don't go to this particular shop and buy this particular thing because I had a very bad experience. So you could suffer the same. Now that shopkeeper cannot file a case of defamation against me, though I have criticized his shop and I have dissuaded customers from heading to that shop, because I am telling this in good faith, because I have brought some product from that particular person I will not trust. This happened very recently. One of my juniors, he got an Ola scooter, and if you see in the entire country, there's an uproar in the kind of service Ola is providing to the scooters. So he took to X, formerly known as Twitter, and he posted the photo of his bike, which was very brand new. And he said that the service offered by you is very bad. It's stopping in between. So if I have paid so much for your scooter, you are supposed to give me good service. You're supposed to give me a good product. Now, Ola cannot sue my junior because he took to a social media platform to criticize that particular scooter, because he's actually doing it in good faith. He's telling the public that if you buy the scooter, you could face this. So therefore, any other company, not just Ola or any other company for that matter, could face the same kind of criticism or hardship through the customers, because a customer always has a right to give a review. So this is only not restricted to customers. Any imputation you make against a service also. If somebody goes and tells I'm not a good lawyer, so therefore client should not approach. If that person is saying it out of nowhere, then that could be a wrong. I could sue that particular person. But if that particular person has been a client or who has consulted me and then did not like my service and told 2 people that Mr. Nair does not give good service, so I cannot sue this particular person for defamation because he or she is well within the rights, even if that person is wrong about that person's opinion, to criticize me, because it will be considered as an imputation made in good faith. Now, all the exceptions which I've told, one second. So I think we have covered all the exceptions in that. We have not covered the aspect of whether this particular aspect of defamation actually can be misused. Any law, if you see, has pros and cons. A law is always enacted for the good so that the people can utilize it for the goodness of the society. But eventually we all know that the law is misused. So there are certain cases. I'm going to come to a very interesting case law. This was a very high trend, not just the case, the entire movement. You all know about the Me Too movement, where a lot of women came out in public and started sharing their experiences about the sexual harassment or the abuses they've been facing, but they never could come out and make out a case, either because of lack of evidence or lack of confidence or or because of societal pressure or whatnot. So when the Me Too movement came in 2020-21, the Chief Metropolitan Court in Delhi actually acquitted a person named a journalist, I think, Priya Ramani. You all may be familiar with this particular case. And the case was instituted by Mr. M.J. Akbar, who was the Minister of State of External Affairs in the then Modi cabinet in 2018. And the case was for a sexual harassment allegation which was made by Priya Ramani in public against this particular person, this minister. And he had to step down as a minister because of the sheer public pressure. And he decided to file a suit of defamation against Ms. Priya Ramani. Now, in his suit of defamation, of course, he said that what Ms. Ramani said in public was defamatory to him because he was a prominent person, he was a minister, and it was done with malice and with the wrong intention. So that particular woman misused the law. Now the court did not find Ms. Ramani guilty of causing defamation to Mr. M.J. Akbar. And the court's finding in this particular matter was that though the thing may or may not be able to be verified accurately with facts or with hard evidence, if a woman comes out in the public and says that this happened to me and she shares a personal experience, the court considered that it is for the public. Whether it is truth or not is a matter of fact. But for the time being, based on a singular statement, as the case stands, the court is of the belief that the woman coming out and telling the truth or the experience that they have faced actually does not amount to defamation. So now this is a very classic case. Now the matter is pending because in the Delhi High Court, where Mr. Akbar has preferred an appeal. So the case is still ongoing at the appellate. But the lower court came to this particular finding that Ms. Ramani did not cause a defamation. And she has apparently produced several witnesses also. But now my question to all of you is, and this is what we need to understand, the pros and cons. If suppose this is public good, of course, some woman or a woman can misuse this as well. So any law which is made with a good intention can always be misused by the other. But so then more or less, the law of defamation comes very thorough with a lot of exception, a lot of elaboration, and a lot of case laws. And we are living at a time where we have to access to a lot of materials that are decided in the past, so that those can act as a guiding principle to the current cases as to whether something amounts to defamation or not. So more or less, I think if I can go a lot into a lot of cases, but I think it is better now that we have a basic understanding of what is defamation under civil law, what is defamation under criminal law. I think we can open the session for a Q&A so that I can address specific questions and we can have a good discussion as to on the questions that I've put before all of you. That what do you think is the scope of misuse? And if there is misuse, what can we do? Of course, in any case, if there is a misuse, we have to keep appealing with whatever evidence we have. But more or less, even if there is a misuse and even if we have the right to appeal, there may be instances where we could just be defamed. So the practicality of manhani is such that it is very difficult in today's generation because there's a lot of material that comes out. A lot of material that comes out, easy access to the internet and social media. If you post something about somebody, it is a very high likelihood that whether a case is instituted or not, that person will actually suffer a lot of consequences. Even if you win the case a little later or maybe after a lot of years, it does not matter because all these years, you actually stand to lose your reputation if the charge against you is false. And so there are two sides to this story. Some get roped in unnecessarily and cases get dragged in court and nothing good comes out to them. They actually end up losing their character and reputation in the society, even though they have not made a mistake. There are others who actually have done it. So therefore, the criticism of the statements against them prove to be a good step to pressurize them. For example, if we see pothole-ridden roads criticism against the government, maybe such a defamatory statement, whether they're involved or not, would actually show that the public is watching you. So sometimes it's a very good thing, even if the law is misused, that there is good public control over our public representatives. So therefore, this particular aspect of defamation has a wide array and it can be misused, but it is still strong and still very exhaustive so that somebody who is trapped will have some way or the other if that person's intention is to fight with hard evidence. So this is the gist of the entire defamation laws in India. So I will open the thing for Q&A and let me see what you all have to say about it.
Advocate Bindra. You see, sir, as an advocate, we basically, look at both sides of the coin. We could be basically defending the victim, defending, the other party. But what I wanted to understand is, typically in these cases, you also have this aspect of compensation, right? And most of the time, you find outlandish amounts, 50 crores, 100 crores, if not more. Is there some sort of a logic that is applied? Is there any mode how you calculate? Because this also becomes like a deterrent. For example, if you have this fancy amount, then the other party is kind of taken aback, and they say, hey, should we really apologize and just get away with it? Because these amounts can be pretty what should I say, scary, if you will.
Understood. See, sir, from what I understood from your question, see, sir, not only in defamation, if you have seen the irony in our country, we are not like the US or other European countries. Let's just say I have a genuine case, I take it to court against you. Now, we both know that the Indian courts will not grant you huge compensation. Now, I may ask 100 crores as a compensation amount, but have you ever seen a case in our country where 100 crores is actually granted as an compensation amount? It never ever. Even getting a few lakhs, this also happens in maintenance laws, domestic violence, 498A, and even penal provisions. If you see, even if a rape victim hardly gets any compensation, even if the rape is true. So imagine we are faced with a situation where we as an advocate or our clients, based on what they feel is their price to amount the damages, they can say 100 crores, 200 crores, 500. But the bottom line is, in India, you're not going to get such a huge compensation. So a person who, at first, this is a tip to all of you. If you believe you have made an honest statement and it is against a big corporation or a big entity, you need not get scared because of a legal notice that may come to you that will sue you for defamation and will take 100 crores of damages. It should not dissuade you. I'll tell you why. Because of the fact that the Indian courts are very empathetic and understanding towards the general public. We know that there's a lot of people who still live under poverty. And because they committed a mistake does not mean they have to sell everything that they have just because this person opposite to you is somebody powerful and has demanded a huge amount of. So there are two aspects to this. You can ask 100 crore as a compensation, and sometimes you will be right in demanding 100. For example, a very big company. For example, tomorrow if I make a very derogatory statement against Infosys, so if I do that statement against Infosys, which is a very good company, and the company believes that that statement was completely unnecessary, which tarnishes its image, causes its stocks to decline, or whatever it may be, they will sue me for 100 crore rupees because they actually might have suffered 100 crore. Now the question before the court is, they sued me for 100 crores. Can I pay 100 crores as a compensation? Do I have the assets to pay them back? Even they know that at the time when they're suing. So what you need to understand is, the amount is not the concern here. It is the intention by which I made the statement against that particular company and whether the company could ascertain damages very well. And if you see under civil law, you have to show your damages. It clearly enlists that a particular damages have to be shown, whether though there is no guiding factor under this, because I told you it gets covered under law of torts. So law of torts is governed by these three principles: justice, equity, and good conscience. So keeping these three principles of justice, equity, and good conscience, how much do you think a civil court in India will grant compensation for defamation? So the practicality of a case turning out to be a huge compensatory case is hardly going to happen. So the deterrent can be on both sides. An ordinary person having no control over that person's tongue says anything and everything against a lot of people who are actually good, have a good reputation, will actually be scared if he receives 100 crore compensation legal notice. So good. So that dissuasion works well. But the practicality of a smart citizen in understanding that my criticism was fair, so I am not going to back off just because somebody wrote they need 200 as damages, crores as damages. Such thing will be protected by the court of law. So we need to have the confidence to come out against somebody big if we believe our opinions or whatever we are going to say is backed by something concrete. So then you need not worry about 100 crores or 200 crores. You tell that to the court. Even if you're convicted, let's just say, even if the person wins the case, the court will always go easy on you. The court will ask you to pay some compensation of 10,000 or 20,000. That's it. That's how it actually goes in practicality. I think you would also agree with me. You're also an advocate. You will have wide stream experience in a lot of cases that you're handling. Compensation, we don't get much in our country. That's a sorry state.
Sure.
Even when people deserve it.
No, absolutely. Even with the the legal fee that we charge or we claim, typically we get a very, very low amount. So
very, very true. And we know that for good service right now, any lawyer would charge somewhere between a lakh or two or something, whether it's bail matter or any matter for that. But the court will give you 10,000 towards cost. You go to consumer forum, you file against a case in the consumer forum. Of the consumer court may only just say return that amount of that particular product. How is this justice? So basically, even when you have a very good case, you are hardly given any compensation. I mean, the compensation is not good Even therefore, I said in defamation cases also, we will never be able to recollect even one case where the compensation has been such magnificent that it actually acted as a deterrent. It never acts as a deterrent. Therefore, we have so many cases of defamation in our country, and most of them are very untrue. So people do it in complete impunity because they know nothing is going to happen, and then it eventually, because the cases take years to be decided, mostly it goes into settlement. Then they post an apology, and it is accepted. That's the practical reality of the situation.
Yep, makes sense. But thank you so much, sir. I think that was truly enlightening.
Thank you.
Your experience, speak. Thank you.
Thank you.
What is the life cycle of a criminal defamation case? Like, what is the starting point?
Starting point of a criminal defamation, like how to sue somebody under the criminal law. Is that the question?
Yeah.
Okay. So, Section 356 under the new BNS and under the old provision of the Indian Penal Code, that is 500, is punishable up to, has an imprisonment which can be extended up to 2 years of imprisonment. Now, because it has a fewer years of imprisonment and is not considered a very serious crime, it comes under the category of non-cognizable offense. So if you head to a police station and you tell the police officer to register an FIR, they will not register the FIR, and they are right about it. So what will happen is a non-cognizable offense report will be registered. So what traditionally people do is, after the registration of NC, or sometimes they even skip this process, they go and file a private complaint. Private complaint before the court of magistrate. You sue that particular. If you are going for criminal defamation, that is what you do. You prefer a private complaint before the metropolitan magistrate or the magistrate of first class or second class. You approach that particular magistrate, you make out your case, you annex whatever the defamatory material is posted against you, and it follows the same process as any private complaint is instituted. So the base process under the new BNS is, as soon as a complaint is made, the magistrate will examine the complainant. It will take his verification on record. If there are any witnesses, those witness statements will be recorded. A notice will be issued to the particular person on the opposite side. What do you have to say about that? And after that, process is issued. So the difference under new law is, first there's a notice, then there is a process. So what I mean by process means the court has taken prima facie cognizance. Prima facie cognizance is taken and trial has started. But whereas a notice is calling upon the particular person to answer why cognizance should not. That is an added safety feature in the BNSs. So simply put, complaint will be examined, complainant will be examined, witnesses will be examined, the opposite party may be heard, and very important, in case of defamation, the Supreme Court has very recently passed a judgment by stating that a magistrate or a judge is well within his or her rights to apply the exemptions. I read out those 10 exemptions. No? Those 10 exemptions can be applied before the stage of issuing process. So if it is a false litigation or a false case of defamation, and if in the opinion of the magistrate, one of the exemptions prevent that particular person from being sued for defamation, he can very well stop the proceedings there as per the Supreme Court guidelines and not issue process of it. So that is how, but if suppose a case is made out and no exemptions is made out according to the magistrate, the case will go based on a private complaint. That is how you take it forward under the private law. And if it is under the civil law, like any suit for recovery or a suit for damages or a suit for compensation can be filed in the form of a plaint. So you have to prepare a plaint, you have to file it as a suit, and then the proceedings under a civil procedure code will start, like any other civil suit. So that is how you sue somebody under the civil law, under the criminal law.
Yeah. Hi, good evening.
Good evening.
I actually wanted to ask this question. In especially in Bombay or in Maharashtra, where we have cooperative housing societies, lots of times you'll find the managing committee will post on the notice board a list of defaulters. Now, sometimes those defaulters' dues are actually, they are in default, and a lot of times what happens is that those amounts are actually disputed. But even with all good sense, sometimes you are unable to actually sort out these matters between the members and the managing committee. So my question here becomes that when such a notice is put up in a prominent place of your housing society, does that or would that amount to defamation of a member?
See, in the end, remember the first exception that I addressed, that truth is a good exception as long as it is for public good. So this comes under that category. Now I'll tell you where this can come under and will not come. So if suppose you also told me that there are some cases where these people are actual default. So
Right.
If the society says that they are defaulters, the first part of this is fulfilled. It is a truth. First, in a case of defamation, what these parameters are applied. Is it the
Right.
truth? Is it not the truth? So this part, truth, tick. Second aspect is what? Is it for public good? Now, in societies, there are a lot of people who actually take advantage. They know that the managing committee members are honorary members. They don't get a salary. They are not paid. They're just doing that because they are elected to do so. They have to, somebody has to run the society, so they do it. So
Right.
some smart members know that even if we don't pay the maintenance, it is not like the society members are actually going to consult a lawyer, approach the registrar for recovery proceeding. They're actually not going to take that steps. So they're like, कि चलो भर लेंगे जब जैसा मन करेंगे तब भरेंगे. So this is actually done with the wrong intention. Now, if posting it on the notice board actually is a established practice where you're doing it for the public good. Basically, if a managing committee posts this on the public notice, that public notice involves the members of that society only. Who's going to see the notice board is those members.
Anybody entering the building?
Yeah, tell me, sir.
Anybody entering the building?
No, anybody entering the building could see, of
Correct.
course. But the whole point is, now that cannot be prevented completely by the society. No, if
Correct.
suppose, let's just say, I'll elaborate on this. So imagine there is a building, there are affected members.
Right.
Now, if the person or the society has not communicated first to this particular erring member that your dues are not clear, and then directly they went on to pay the defaulters list, then of course, because you look at the circumstances, no opportunity was given to this defaulting member to come clean or dispute the same.
Okay.
Or if the dispute, in the opinion of the society, does not stand, I told you the two remedies before the society is actually to proceed legally, approach the registrar or somebody, and then take appropriate orders, which actually will cost a lot of legal fees to the particular society.
Right.
So it is a time-consuming process. A lot of efforts have to be put in. A lot of money has to be.
Right.
So it actually is not in the interest of the society to pursue a case of recovery against small defaults.
Right.
But if this putting the notice on the public notice board acts as a dissuasion to that erring member who's actually taking advantage of the society's goodness, in that particular aspect, it creates a kind of force and pressure on this particular person to pay up, and it is in the benefit of all the other society members because then they do not have to shell out that legal money for that recovery proceeding.
Right.
So if you see, in my opinion, it fits in the exception number one. But like I told you, if no opportunity is given and the society or the managing committee is in the habitual practice of immediately posting notices on the notice board for everybody to see, without giving a good opportunity to the person to get back on that, then yes, I think the person can argue a good case of defamation.
And what in the case where the amount is actually disputed and the society or the managing committee is aware that there is a dispute, but they are still posting it as per their...
So see, again, now you have a situation where you have disputed. So if there is a dispute, ideally the society is supposed to take it forward legally.
Right.
If they do not agree with your standpoint, and if they believe you are wrong and they are right, they should proceed legally. Now, if they're just posting it to defame you, of course, I think the person has a healthy case there. Again, it will be a matter for the judge to decide because, like I told you, in all exception, what is for public good is a matter of fact. It's not a matter of law.
Right.
So you have to, both the parties will have to show to the court that does this amount to public good or it does not amount to public.
Right.
So if suppose you are successfully, if you are the defaulting member and you are able to make a successful claim against the society by stating that no public good came out of it, society members were lazy enough to not make a case against me.
Right.
And just to defame me, they just did it, and they do it periodically, even with me asking them to take it down. If you get no good attempts from your end, and the society is just simply posting it on the notice board, I think a case of defamation can be made out.
Okay.
Because, like I told you, it's a matter of fact. A matter of fact has to be adjudicated by the court.
Right.
So both parties will lead their arguments, and if the court finds merit in the submission of the defaulter that I am willing to pay provided this disputed part is clear, so that means you are right. Then what was the need to post that public notice?
Right.
So that is how it goes. So I think it can come under the exception number one, or it could not. It would really depend on the nature of the disputed society fees that will be taken to the court.
So the court would actually take into consideration in this case that if the complainant is actually able to prove that the disputed amount is actually correct.
So if the complainant and the court will not go much detail into it because this is not a recovery procedure.
Right.
The court is not there to adjudicate whether the society's recovery amount or this person's recovery amount is right.
Absolutely.
Court is looking at the conduct of both the parties here.
Absolutely.
Because information is made out.
Absolutely. Correct.
So if the conduct, if you can show that on the face of it, your objection towards that particular fees levied by the society, on the face of it is only wrong, then that means the society is taking undue advantage and putting social pressure on you so that you pay up something that basically they are committing extortion, if you see.
Correct.
So they are putting public pressure on you so that you feel secluded or shunned in the society where you're staying.
Right.
And then they are trying to recover that amount, which they know is actually illegal.
Right.
So they're just disputing it for the sake of it.
It's
So
like
you have a
name and
very good
shame.
case.
It's like name and shame, basically,
Exactly.
on those bases.
Exactly.
So this would actually become a civil, or would it be a criminal defamation in this case?
See, like I told you, every defamation can be both civil and criminal. It
Right.
actually depends on you
Mhm.
which provision of law you want to invoke.
Okay.
So if you want compensation and damages, you can invoke the civil law.
Okay.
If you can invoke, if you want the person to be punished with imprisonment, or you want it to be recorded as he's like a convicted person under the
Right.
criminal law, you
Right.
have to file a criminal case.
Criminal
But it is
case.
completely discretionary up to you. Like I told you, the definition of defamation is not there in civil law. It's actually defined under criminal law.
Criminal law.
So a lot of times the exceptions and the guidelines given under criminal law is actually adopted by the civil law.
Okay.
Practically speaking. So it will not observe in the order. A judge who, a district or a magistrate who, because he is well versed with both the laws, he will just see the guidelines which is there in the criminal law and see whether a civil case is made up.
Oh, I see. Okay.
So that is how practically judges apply, because a codified law under the penal provision explains the exceptions very well with illustration.
Okay.
So if under the criminal, so the whole point is under civil law, the plaintiff has to prove by the logic of preponderance of probabilities. You do not have to prove it beyond reasonable doubt.
Yeah. Okay.
Because the person is not going to be imprisoned. So you have to tell the civil court that from the material available, more or less it is seen that the case is in my favor.
Right.
This is enough in civil law.
Right.
But in criminal law, you have to show it beyond reasonable doubt.
Beyond reasonable doubt. Right.
So therefore, the degree of proof is the difference in both these cases.
Oh, I see.
So if in the criminal law, if you can prove a case based on preponderance of probabilities, you could not prove it beyond reasonable doubt.
Okay.
So you may not succeed under criminal law.
Right.
But that same defense strategy or the same prosecution strategy you apply under civil law, you may actually win the case for compensation.
Okay.
So you have to take a call whether you have enough material to get a person convicted for defamation under criminal law, or do you have enough material to get compensation out of the person under civil law.
Under civil law.
So you have to take a smart call based on the material available before you, which law to pursue.
And one last question on this. I'm sorry I'm taking so much of your time.
No problem, no problem.
When something like this is filed, is it under personal name of the managing committee, or does it actually be against the managing committee of the society? Like, you
that
have...
also depends. So, for example, I will tell you what comes under the purview of the society.
Please.
So, if something is approved by the general body of the society in majority, then basically the managing committee is only acting under the orders of the general body.
Okay.
So, if the general body approves of whatever amount is due or whatever the dispute is, and the general body in majority supports the decision of the managing committee, then basically the society as a whole is defaming you.
Right. Okay.
If you see in a manner of speaking.
Right. Understood.
So basically, then society becomes like a corporate company. Like it's like one corporate company filing a case of defamation against another corporate company. Though it would be the people involved there. The name of the person who's filing, if it is taken in the form of a resolution where people vote on it as per the law laid down under the bylaws or under the Maharashtra Cooperative Societies Act, then it becomes a body decision. So if it's a body decision, you sue the entity.
Right. Okay.
But if you believe that the general body has not authorized it, and some office bearers of the managing committee are doing it in their personal capacity to defame you, misusing it. Basically, then it becomes a colorable use of their power.
Right.
So you have to make a case in court based on that they are misusing their authority as secretary, chairman, or whatever the members of the management committee is, and they are using that particular law to defame you even when there is no dispute. So before you proceed to the court, then it becomes your duty to involve the general body. You have to raise this issue before the general body.
Okay.
And then you have to see how much is the support of the members supporting. So if it is not authorized by the general body and it is only the managing committee, then you have to go personally against those members of the managing committee. Because then it is not warranted by the society. So you cannot say the society is wrong.
Right.
So it's like that.
Got it. Thank you so much. Thank you.
Sir, I just wanted to, you've answered part of the question regarding the damages, but I just wanted to know how long does it take to get some kind of relief from the courts, or does it work like takes time like normal civil cases?
See, in order to get your final damages, like the final amount of compensation, if suppose let's just say somebody has defamed you and you have seeked the damages or compensation of around 20 lakh rupees. In order to get this 20 lakh, it may take 4 or 5 years. in my experience.
Okay.
But if suppose let's just say
criminal.
somebody is defaming you consistently, let's just say some post is made about you on social media, and that person is consistently trying to post more stuff about you or communicate back, the aspect of injunction can come in very high favor for you. So if you say you make a civil case and you make an application for temporary injunction before that particular court which is hearing your matter, and if the court grants the injunction, injunctions are heard on priority basis. So that will not take time. It is heard in a similar manner like how bail applications are heard.
Right.
So if you make an application for injunction before the civil court and tell the civil court so and so material is being posted online against me consistently almost every day, and it can happen in the future also by this particular person or this particular entity. Therefore, I want the court to injunct them from doing that. So the court may issue this as a temporary and urgent order in your favor if you make out a case. So at least you can be under the relief that particular person against whom you have made the case will not post anything further derogatory against you. So this is one very good relief.
Even by telephone calls or something.
What?
Can it be by telephone calls also?
Can it be by as I'm sorry.
As a defamation, like somebody would be personally abusing on the telephone calls or something.
For defamation to be involved, somebody has to defame you before a third party. Defamation cannot be between two people. Like we both speak right now, and I say something against you. If nobody heard it, then it is not defamation. It is a personal case. Like you can file a personal case of whatever against, like I abused you under the penal laws of that. I assaulted you. Those personal cases can lie against me, but you cannot sue me for defamation because nobody heard it. Who, in the eyes of whom did you come down? Your character came down, or your reputation came down.
Has to be somewhat public.
What?
Yeah, somewhat public.
So I'm so sorry. I did not hear you.
That it has to be public.
Yeah, it has to not public in the sense 100 people should be involved. Even if one person hears me say that against you, you're defamed in the eyes of that particular individual. So yeah, case lies against you. In short, somebody apart from two people in there.
So where can we read about how to file a
how to file? Could you? I'm so sorry. I cannot hear you. Your voice is breaking.
Many times in matrimonial cases, they want to file defamation. But I'm not exactly sure where to read the provisions. So can you give me some guidance on that?
Wait. I may have lost few words here and there. You said
Can you suggest some reference material for
reference material to read about? I think NC, the point is there are a best way to read about defamation is to actually just, I use live law and then I use Manupatra or SEC and all to just see judgments. So under criminal law of defamation, if you want to really see, just follow up with the good cases. I think Subramaniam Swamy was sent to, was it the Mr. Subramaniam Swamy, who was just recently convicted for 15 days imprisonment?
No, Sanjay Raut.
Sanjay Raut, sorry, I'm so sorry. Mr. Sanjay Raut was just recently convicted for, I think, a 15-day simple imprisonment was given by some court. So if you see a lot of cases, Mr. Rahul Gandhi was convicted for 2 years of imprisonment, which was stayed by the Supreme Court later. So if you want to understand defamation from a criminal law standpoint, it is very good to read judgments. Any conviction order or any acquittal order in case of criminal defamation, if you read those orders, the judges go on to explain the kind of evidence that they appreciated, the kind of cases or the kinds of word that was used as a defamatory, and the amount of people it reached. So you will actually get a fair idea about how a person made a case of defamation against another person, and what was the opinion of the court in that, and what was the evidence that led, and how somebody could prove the case in their favor. There are n number of cases. Even if you put it simply on Google, also recent sensational defamation cases, you will actually get to read a lot of judgments of the High Court, Supreme Court, or the trial courts. So information is plenty, man. You can actually get it online very easily.
And matrimonial cases, specifically in matrimonial cases.
Could you give me an example? What do you mean by matrimonial cases? Like, I understand what matrimonial matters are. What I meant is, what is the aspect of defamation?
Yeah.
Can you give me an example of defamation in matrimonial?
So the husband has given the wife.
I just remembered a case of mine. There was a matrimonial dispute in which I represented the husband in a divorce proceeding, and the wife of this particular husband, the former wife of this particular husband, filed a nullity petition under the Hindu Marriage Act. And in that nullity petition, she alleged that the husband was impotent. Now, she did not back it up with any theory. The husband and the wife has never even lived together. So how could she make a statement that the person is impotent in open court? So this can amount to defamation. So since you said matrimonial dispute, a case of mine came on this particular time. So if suppose, let's just say a person has made wrongful submission before the court just to malign your image, then after the proceedings are concluded, you have to first fight and win that particular case there. Because what if you're actually impotent? Then you're making it before. I told you one of the exception is to make a statement before a lawful authority. So if the wife is seeking divorce on a valid ground of impotency, then the wife is right in saying that the husband is impotent. But if the wife is faking this aspect of impotency just to get a divorce or to defame the husband, you have to win the case in the family court. And then you have to show that no material was advanced and this was just a ruse to actually spoil my image. So then you can actually make a case for making false representation to the court, giving false affidavit to the court, which is punishable under the Indian Penal Code, and sections of defamation will also be revoked because you did it to actually utilize the court as an infrastructure to take out your personal vengeance on that particular case. So similarly, in matrimonial disputes, if something has happened to you, where somebody has just used the court or the divorce proceedings or any other matrimonial proceeding just to wreak vengeance on you or to defame your name, then you can very well, but you'll have to win the case there. Because in matrimonial cases, these grounds are important for seeking a divorce, of a custody, of any other matter. So when the matter is sub judice before that particular court and such allegation is made against you, you have to obtain it in an order from that particular court that those allegations were found to be untrue with material. So then you have a healthy case and you can sue that particular person for defamation. That is what you're supposed to do.
Thank you so much, sir. Thank you. Really answered my query. Thank you so much. Thank you.
Vinay, regarding matrimonial dispute, there's one query in the chat box. If there is a fake, a false DV and 498A case, so can a defamation case be instituted?
Very well. So that's what I'm trying to tell you. When any cases in matrimony or any law, for example, let's just say tomorrow somebody makes a case of fraud against me, that I am a fraudulent advocate who conspired with my client to obtain some money illegally from some third party who's involved in a case of. Now, this is very atrocious allegation against me. But as the allegation stands, if there is a case with that particular client and the materials divulged prima facie shows that some money was transferred and these people are involved, I cannot at that particular stage file a case of defamation. And if I do file a case of defamation against that particular person who said it, I have to lead in that I'm saying 490 right under 356 now under BNS. If I lead evidence, I will have to show and prove it beyond reasonable doubt that person made an unfounded allegation against. Now, I can prove that allegation of unfoundedness if a matter is already going on here. Like you said, 498 or matrimonial dispute. I already gave you that impotency example. So if under 498A, wife has leveled allegation against, of course it causes defamation. But what if the wife is true? So therefore, any court of defamation would wait for the verdict of that particular court which is hearing the 498A case. Because the 498A case related evidence of abuse or whatever trauma that the wife has experienced, she will be leading the evidence of that particular accusation before the court of law there. So if the court of law arrives at a successful judgment, acquitting the husband and saying that the wife apparently made a false case, if you have it on record, so even instituting a false case is punishable under the penal laws. Along with that, the defamation provision will also be added. So there is no absolute bar which mandates you to win a case first to sue somebody for defamation. But without winning the case, if you sue somebody for defamation under the criminal law, you basically are trying to invoke two courts on the same subject matter, because the defamation court will require the same materials that the other party is going to file before that court to see whether the allegation is actually untrue or not. Because like I told you, it has to be true for public good or true for your own good. So if that particular person can come under that exception, that I in 498A case told that my husband abuses me because it is for my own good. I'm the victim. I'm being abused, and I don't want to stay with this particular man. So even if that man gets defamed, intention of the wife was what? To actually get protection from him and to actually get divorced from him. So even if the husband loses his standing in the society, it does not matter if the claim was true. So both the defamation court and the 498 court will both want to know whether the wife's allegation is true or not. So she has to prove her case there. And the same material have to be used in the 499 proceeding and now 356 under BNS. So I hope that answers your query. So the best way to pursue for defamation is to win the particular case where defamatory remarks were made against you. Because then you can go with that court order and show that a false case is instituted against you.
Got it.
Sir, I'm in the teaching profession and I'm working in a government aided institute. Last year, I complained against my HOD under Harassment at Workplace Act.
Okay.
My HOD got so infuriated that later on he started everything to throw me out of the department.
Okay.
And did not succeed. What he did, he just influenced students of my department
Okay.
and put the students some investment and forced them to write to get an ill things against me. And
Okay.
made the student to send the letters to government office.
Okay.
Student did, and the government formed a committee. The committee came over to our college, and the committee, called the students and asked them the truth about behind this. So
Okay.
the students broke down because when they started questioning the students, students and they admitted to having wrote the letters under that person's instructions,
Okay.
and so they told everything before the committee.
Okay.
But the to take any action against that particular person. Now, my question is that I mean, this does it come under, I mean, does it mount to defamation case? Can I go with?
Ma'am, in your particular case, what has happened is a much serious offense than defamation. Defamation is actually I would say it is in the bottom. You have a much serious case because if you see, there was a proper criminal conspiracy to get you thrown out.
Right.
If you see, you were a victim of sexual harassment. You
Right.
made a case under the POSH Act. You approached the authorities, you made a good case, and apparently that is that particular person against whom you stood up.
Right.
So what he did was not with the sole intention of just defaming you. He did it to get you thrown out in order to get you backed out. So he is basically committing witness tampering here. He is coercing you. It is, in a manner speaking, extortion. The person is attacking or injuring your professional life so that you come under the pressure to give up that allegation against.
Right.
So if you see, the punishment for extortion is around 10 years of imprisonment, whereas the punishment for defamation is 2 years. I mean, I'm just an advocate. When you told me this issue right now, I don't see defamation as the first issue here. Of course it is. In this particular aspect, unfortunately, the students who wrote the letter against you, unless they can prove coercion from this particular person, they also become co-conspirators. Because apparently, after the fact, the truth is this, that they colluded with this particular man to get you defamed in that class or in that particular department or in the entire society for that matter. So defamation, of course, 100%. But more than defamation, I believe this is a case of extortion and witness tampering. So you have a very good, strong case against this particular man.
So what should
tell me what?
What should I do after that? I mean, how to go for this extortion?
Ma'am, for that, I think you will have to hire me as your lawyer. Because we have to sit down and we have to discuss a proper strategy in case if you want my opinion on that. I mean, if suppose we do that right now, I think everybody will actually just keep asking me on how to pursue personal cases. But I would really like to appreciate you standing strong. I mean, if this is what actually happened to you, that means you have been strong from the very beginning and you've handled a lot of people at once. So hats off to you, man. If you're right in this, then you have faced a lot of bad people together. And I'm glad that it came out well for you and that the truth came out and the students finally said that it was under the pressure. So, ma'am, if you have to reach out for further, I mean, what action needs to be taken off, please stay in touch with my office. We'll help you how much. Only thing is that I don't want to delay the other participants by just focusing on that because it may definitely take 10-15 minutes to guide you further.
Okay. So thank you so much for guiding me. Thank you.
Welcome. I wish you all the best for your case.
So I have one scenario. A person shared a video on Google Drive about a third part. That's shared personally to a person through Google Drive. A person shared a video.
Okay, a person
about a third person in a Google Drive. So personally, Google Drive.
What did the person do on Google Drive?
He shared the video.
Okay, he shared a video on his Google Drive.
Sir, have you written your query in the chat? Is this your chat? A person recorded someone's video and shared the video on Google Drive with two other persons.
Okay. I shared somebody's video on Google Drive to 2-3 other people. I got it right?
Yes.
Okay.
Yeah.
So now you can continue with your question. What else? So what?
Google Drive, person shared a video to a person through his personal mail ID and it is through Google Drive. And that person has downloaded the video and shared to other 3 persons.
Okay.
And now the person shared the video. The internet person has filed a defamation suit with the person who shared the video. But he didn't share the video. He shared the video only to one person.
That's what I'm trying to tell you, sir. I think in one of the queries that came just before 2-3 queries before, somebody asked me whether I think there's a lady who asked me whether it will amount to defamation if 2 people have a conversation with each other. So I said that will not amount to defamation because there's no third person involved. Here, if you see, if the person who shared that video on the Google Drive and that video was concerning some other individual. And the person who shared the video is not that individual. He has actually got a third party involved. So the defamation started from that point of time. The moment he shared that video to that person, he has and if that video was defamatory in nature, he has defamed whoever was in the video the moment he shared the first time to that particular person. I think in one of the recent cases, Mr. Arvind Kejriwal, who was the then Delhi Chief Minister, was actually roped in a case for defamation for retweeting something. So the actual tweet was of somebody else, but Mr. Kejriwal retweeted that tweet. So just because he retweeted it, he got booked for defamation. And even that particular person who actually had made the first. So the whole aspect here is between if you and me, sir, we abused each other and you said something terrible about me, that I am not a good, whatever it may be. You telling that to me is fine. If you share a video which shows me in bad light to somebody else, I am defamed at that very moment, no sir. Now let's just say that video was circulated to 100 other people. You did not send it to 100 people, but that person sent it to 100 people. But you become the originator. The video originated from who? The person who sent the video first. So then he becomes a co-conspirator. The whole idea of section 34, acting on common intention, don't you think, sir, it could also be planned? Let's just say I send that video to this particular person. I would very well know that this person has a nature of sharing it with 100 people. So maybe I wanted that. So in order, I use that particular person to get the information out to 100 people, which I personally did not want to. But I should be held responsible for this, right? So you understand how the law operates here?
Again, sir, one more thing, in that mail, that particular person has mentioned clearly that don't share this message. If you share
it could be a clear co-conspiration still, no sir. Let's just say I know that you are a person who will share anything and everything that I send to you. And let's just say one fine day I send you a video and I say, please don't share it with anybody. I'm actually just teasing you here. I know you will still send it. It's like you tell a secret to a friend, a category of friend who you know who very well loves to gossip. So if you tell a secret to that person who loves gossiping, do you really believe that the person will not tell the other person? So it is very difficult to trace the characteristics of the people involved here. So the simple definition of defamation therefore is on this base fact that if two people are involved, fine. But if a third person is involved and you tell about this particular person to that third person, and if it is baseless, it is defamatory. Therefore, it does not matter whether one person knows it or 100% knows it. Defamation happened the moment that particular person shared that email to that other person. Defamation has already happened there. Even if let's just say that person would not have shared it with 100 people, if the person in the video comes to know that two people shared that video amongst each other, which was against me, I can still sue that particular person for defamation. You understand the legal technicality that I'm trying to explain to you.
Google Drive is no. If you unshare the Google Drive, no, the particular video is not accessible. But before that, it may be downloaded. In this case, no, any that's for Google Drive.
Are you trying to tell me, sir, it was accidental?
Yeah, that we can.
No, but that's the whole point I'm trying to tell you. No, you tell me, was it accidental for that particular person when he shared that email to that other person? Only that transaction. Don't go to the other part where he shared it to many people. I'm only asking about that first part of the transaction, where he sent the video in Google Drive via email to that other person. And if that content of the video was defamatory to somebody else, when he shared it to the other party, that was with complete knowledge, no?
Yes.
That was not accidental,
yes,
right? The first sharing of the video was not accidental, right?
Not accidental.
So then you will come under defamation, sir. Unfortunately, you will. I mean, whoever that particular person is, because then that person cannot have the defense that it was accident because he intentionally sent that video to that other person through email, through his own Google Drive. So, like I told you, defamation happened at that very moment. It does not matter now how many people will it be shared.
Good evening, Vinay sir. My name is Murtaza. I posted on the chat that my secretary has posted some remarks on WhatsApp group about my activism and alluding me that I am the complainant to the income tax department because they received some income tax notices about defaults. So without taking the name, they defame me on the WhatsApp groups of the society, and then they public started reprimanding that I am the culprit and I am the complainant, although they do not have any material evidence to prove that I am the complainant to the income tax department.
So let me understand this, sir. You made a complaint to a lawful authority. Here, that is the income tax authorities. You made a complaint to the lawful authority.
That is not public, sir. That is not public. It's that they got the intelligence from the income tax inspector saying that I am the complainant. but
Okay.
they are not supposed to disclose this as per the
Okay.
IT Act.
Right.
But still, the moot point is that the secretary made these WhatsApp group remarks, announcing that I am one of the members of the society is complaining to the IT Act, IT authority, and society is suffering. So that with the intention to defame me, will it count as a defamation?
No, so how would you show this as an intention to defame? See, you complained. I mean, see, we have to peruse the facts very thoroughly in this. But I will touch upon the outline of it so as to not take up much time in this particular query. But let me try to help you out. See, if suppose you have made a complaint before the income tax authorities and you don't want the other members to find out, right? And apparently, yeah, no problem. So you made a complaint to the authorities and you don't want anybody else in the society to come to know about that particular complaint. And apparently somebody from the secretary of the society shared it in the group that this particular member is, without taking your name, making false complaint before the income tax authorities, right? So, it will amount to defamation from the information that you have told me, only if your complaint is false. So, for example, if your complaint is false, if your complaint is true, I'm so sorry. One second. Let me just understand. You made a complaint to the income tax authorities, and you might have made an honest complaint to the income tax authorities. But apparently, this is the secretary saying that you're making false complaints.
Saying no. The complaint was genuine and it was true. The secretary is not denying that it is not true, but they just want to portray me as a troublemaker, and that's why they started.
No, but sir, unfortunately, unless he says that you made a false complaint, unless he says that, see, he has to use the word troublemaker. Has he used the word troublemaker or anything that is derogatory against you? See, if he just, if he makes people assume you are the troublemaker just because you're dragging them into a proceeding, that by itself will not be defamatory because he has to use some defamatory word against you. If he says that, oh, he's a troublemaker he may not be denying that you have made a false, that you have made a genuine complaint. But the point is, he must impute some accusation against you, which is in the nature to show you in the bad light. It is not an assumption that you could draw. Even if members are drawing the assumption because of this man, we are all dragged in. Members could be drawing that assumption. But from the wordings of the messages that he posts, there has to be some clarity as to some remark that is made, which is unparliamentary. There has to be some unparliamentary remark against. If there's some unparliamentary remark against you, then it is defamation. Otherwise, he's just pointing out to some fact which is true.
Correct.
And if he says it is just like information, then it becomes under the exception 1, telling the truth in public good. Like he is doing this to dispense information within the society that this is happening in our society. So he is basically making the members aware. If you see, it can be interpreted like that. Even though it is going against you, he will come up with this defense that I'm doing it for public good of the society. That I'm just informing the members as a secretary. It is my duty to inform them about the information that I came to know. Okay. So actual flaw here, the actual mistake is committed by the IT authorities who went in contravention of the provisions of the IT Act by revealing your name.
Correct. Okay.
Not the secretary. The last point, basically, he's just taking advantage of the situation.
Correct. And what about the word harassment and nuisance used in the minutes of the meeting officially?
Harassment and nuisance. For example, if you preferred a genuine complaint before any genuine public authority,
correct,
and people call it like an harassment or nuisance, then of course they're defaming. These two words will be defamatory because, like I told you, this is unnecessary because unless they can prove it is harassment or it is like a nuisance. So then, if suppose it's like you are making a case before somebody, and just because somebody is like just say there was some crime happened in your society, you inform the police, and the police called 10 people of your society as a witness. Now those 10 people who are called as a witness, they say it in the group that because of this man, everybody is troubled.
Correct.
So this is defamatory because actually you acted as per law.
Correct.
Just because the others were troubled does not mean they can actually censure you. They don't have that right.
Fine.
So yes, so harassment and nuisance and all, you have a scope to make a case of defamation.
Yeah. Okay, that is there on the minutes of the meeting.
Yes. So that is there because your complaint is true, so they cannot just tarnish your name like that. Is
fine. Okay, sir. Thank you so much.
Good evening, sir.
Good evening.
Actually, my question is very simple. You said if A says that B is a habitual means he's watch pawns in society. If he's claim A, then if I posted on some social media that one of the actress is a porn star and
Okay.
tagged that person, then is it a defamation?
Yeah, I mean, seriously, the point is, even if that particular person is a porn star, if you have not taken consent from that particular person, no, whether you can reveal the name in a post. So let's just say you are A and somebody is B, and B is accustomed to watching porn in the society, and you are aware about this. So this is a true fact. Why would you post this on social media? What is the public good that you're trying to bring out of this? What are you trying? So you have to show, no, that this is for public good. If it is not for public good, anything that you do which concerns a private act of an individual will always be defamatory, because in the end it actually penetrates into the personal space of B who is watching that, and that particular person, whoever is a porn star involved there. So two people are involved here. If you take these two people's name in public and nothing public good comes out of it, you're actually defaming both of them, because you have to show your intention why you made that post. No, you actually did it for fun. You actually wanted the society to judge them, the porn star also, and that particular person who watches the porn also. Because can you justify this? If you cannot justify this, then you do not have a good case under the exception. So the person can sue you for defamation.
Okay, sir. But जो जो ऑनलाइन प्लेटफॉर्म पे जो कुछ हो रहा है उसको सर्च कैसे करेंगे? वो अनोनिमसली वो सब कुछ पोस्ट हो रहा है, फिर
नहीं,
वहां पे
सो सर,
किस
अगर
किस
अभी आप, हेलो,
हाँ, हेलो, आवाज आ रहा है?
हाँ अभी आ रही है। देखो, अगर क्रिमिनल केस है तो इवन इफ समबडी इज डूइंग समथिंग एनोनिमसली, एफआईआर कैन बी रजिस्टर्ड अगेंस्ट एन एनोनिमस पर्सन आल्सो।
ओके,
तो ऐसा नेसेसरी नहीं है कि वो आपको उसका नाम चाहिए। तो अगर किसी ने एनोनिमसली भी आपके खिलाफ कुछ पोस्ट किया, यू कैन ऑफ कोर्स फाइल अ केस ऑफ डिफेमेशन अगेंस्ट दैट पर्टिकुलर पर्सन. Then it is for the law enforcement to find out who that particular person is. So the provisions of IT Act will also be attracted. Information Technology Act bhi aayega, because somebody is using, basically they're committing a cyber crime also. So it amounts to cyber defamation. So they will be punished under the IT Act as well as the relevant provisions of the penal code that we discussed.
Okay, sir. Thank you.
Well,
yeah, thank you, ma'am. Vinay sir, most of the questions is already solved. Only, and you have taken a very wonderful session. Always I attended your sessions. And one last question is general public can sue politicians because of their defamatory statements in the public's meetings and all?
See, I'll tell you, sir. So there are two aspects of addressing this. Under civil law, because it's a claim for compensation, everybody cannot go there, because someone has to prove their locus. Locus means you're standing for the case, because you are saying that some damage has occurred to you. Okay. So I'm talking about the civil law first. So under the civil law, the person needs to show damages to the court. Okay. Like, because of so and so defamatory statement against me or my company or whatever it may be, I lost A, B, C, D. If you show this case to the court, you are entitled for damages if you prove your case to be right, as per that preponderance of probability concept that I explained.
Okay.
So in civil law, of course, you need to have locus. Anybody just cannot come and say. And if anybody comes, that person has to show damages on their end. If they cannot show damages, of course, the case will not survive at all.
So on a widespread, can we do this? Suppose I will not take a name of any politicians, but some of the politicians, they're using the human deity's name. Some of the politicians, they're taking the wrongly misleading the general public by stating many wrong statements. Being an advocate, when we are watching news also on the television, we come to know that this is not correct, this is wrong.
Oh, so sir, in this, I think you might have already done it. You will not be the first one. There are many cases that people like advocates like us or any social activists or civil servants, they actually go and they do take up issue like this by cognizance. You know how? So this what you're talking about amounts to criminal defamation.
Oh,
this is not civil defamation. This is criminal defamation. And this is not only criminal defamation, it is also inciting hatred. There is a different provision under the penal law, if you may already be aware about that. So inciting communal violence or inciting people bringing caste, creed or any other aspect into this, which you probably knows that if you make such a statement, it will cause chaos or a law and order situation. Other aspects of the penal laws are also attracted here. So if you, under the criminal law, sir, if you see, what do you need to set the criminal law in motion? The erstwhile 154(1), that if you have a cognizable offense, you go to the police, it is taken down either in writing or you have to give a written complaint. And if a cognizable offence is made out, an FIR is registered. Now
Okay.
under BNS, I think it is 173 of BNS for
Well-
information of cognizable offences.
Yes.
So if you go to the police under the criminal law, you are not going there as an individual who's affected. Of course, you can be an individual, but let's just say you know that there are hundreds of people who may be affected by the statement, but you are the one who is going. So therefore, you're an advocate, you would know, you are called as an informant.
Okay.
The actual term used under the criminal law by the High Courts and the Supreme Court is what we call in Marathi firyadi. Firyadincha manna ahe.
Okay.
And so that means you are an informant. So an informant may or may not be a directly affected victim. He or she is just setting the criminal law in motion.
Okay.
So even if you are not directly affected by that, yahan pe you don't have to show locus. You don't have to show that you personally were attacked by this person.
Okay.
You can say that this has probability to incite violence or it may cause communal disharmony and defamation about the people involved. So basically, yahan pe you indirectly become a representative of the actual people who are affected. So the police are supposed to take your statement, verify your facts, register an FIR, investigate and find out whether the information given by you amounts to a proper case for the court to try or not. Depending on that, they will decide whether charge sheet has to be filed or not.
Okay. Wonderful.
You
Thank you.
got that? What I'm trying to
Yeah,
do?
yeah. Convinced.
So under criminal law, yes. Civil law, you need locus, sir.
Okay. Thank you so much. Thank you. Thanks for your valuable time.
Thank you. Thank you so much.
So Vinay, we can formally conclude the session now.
Thank you. Thank you so much.
So thank you so much, Vinay, for sharing your valuable insights, and it was really an illuminating talk. And again, special thanks to you for addressing all the queries so patiently. Thank you so much.
Always welcome, Lal.